Thank you, Judge. The appeal hearing is in the matter of CA 007-2021 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Sir Jeremy Cooke, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The appellant is represented by Horizons & Co. Lead counsel is Alexander Burrell. The respondent is represented by Azhari Legal Consultancy. Lead counsel is Dr. Rasan Azhari.
Okay, the appellant is Mr. Alexander and Dr. Azhari. There are a few clarifications that we need before we start off with the hearing. And I think I'll invite Sir Jeremy to speak first. Jeremy, would you like to raise those issues that we discussed earlier?
Yes, all right. Thank you. The real question that I think the court would like to hear is where this case is going, both on the state of affairs and what would happen if the appeal was allowed. As we understand it, as matters stand, the position that the judge has decided is that there's no valid claim pleaded against either of the defendants, and indeed the claim has been struck out, and there is no valid counterclaim because that's been struck out. But there remains in existence a contract in the terms of the settlement agreement, which it is recognized it has not been fulfilled because there have been no deliveries other than the kerosene delivery and the very first delivery. That period has long since expired for delivery, March 2021 being the last date. So what is going to happen to the 8 million odd debt that is recognized as being due from one party or the other, and one takes it as being the second defendant on the basis of the settlement agreement? Now, there remains that 8 million outstanding, and there is a counterclaim which is the subject of this appeal, and that is the only subject of this appeal, for a much lesser sum. So where's all this going?
Well, see, let me comment on this. The parties or the respondent will file quite soon a new case against Cohenrich.
Right.
And see, this appeal, of course, has some effect or effect on the new case Cohenrich. The respondent will file against Cohenrich.
Yes, well, that if you're going to file a new case, and if, for example, this appeal was allowed, just for the sake of argument, then the logical thing would be for those two matters to be joined and heard together, wouldn't it?
I fully agree, yes.
Right. What does Mr. Burrell have to say about that?
Yes, my lord, if indeed that is what transpires, that would be the logical action to take. As far as the appellant is concerned, any claim to be brought by Rada is a matter for them. It is noted that the claim was struck out as opposed to dismissed, of course, and Dr. Azhari's comments just then are noted. For our purposes and for the purposes of the appellant, this is our claim, and so this is what we are pursuing at this stage. If it transpires that this appeal is allowed and the respondent files a claim against Cohenrich, then of course, yes, the joining of those two cases would be the most logical. The only additional point that I would add, my lord, is that the parties have been involved in extensive negotiations.
Yes.
Ultimately, this hearing date was in fact adjourned for that reason. It wouldn't have been adjourned if there wasn't a realistic possibility of settlement. And it is submitted that the result of this appeal may well assist either party in relation to, or both parties in relation to, actually coming to terms finally. As I understand it, it was very close. The outcome of those negotiations, unfortunately, didn't quite get there at this stage, but it is hoped that future negotiations may be more fruitful.
So if we were to decide that there has been a valid
Chief Justice, you are on mute.
in terms of the variation of the contract and so on and so forth, the likelihood is that this matter will then settle, is what you're really telling us.
Well, of course, my lord, it's impossible to predict what will happen.
Of course, I understand.
But I think a decision either way is likely to give the parties some assistance on where they stand, right. Whether that's tactically or regarding the substance. However it stands, I certainly think that it'll give the parties some direction. But yes, I think once this piece of the litigation is resolved, albeit there'll be further litigation after that, assuming there is a settlement, I think that would assist. But of course, who's to know?
No, understood.
Yeah.
Understood.
Yeah.
Of course,
Yeah,
there are unpredictable elements in all of this. But let me just ask you two more questions in relation to your appeal. It was struck out on the basis, essentially, your counterclaim was struck out on the basis, essentially, that you hadn't pleaded a sufficiently pleaded a variation. But was there any exploration of the evidence at all? I'm not conscious of having seen the emails of the 12th and 18th of August that were pleaded. They're not in the bundle for the appeal, so far as I can see.
No, my lord, quite right, and indeed that is one of the submissions that I have for today. Yes. In that there was no exploration of the evidentiary impact of the alleged variation. They weren't attached to the pleading, as indeed it's not common to attach all of the necessary evidence to a pleading. They still haven't been attached, as we've not reached the evidentiary stage of the proceedings. So the evidentiary basis for the variation was not explored by His Excellency Al-Mahari, nor are they attached to the bundle for this.
Okay. And the strikeout proceeded on the basis simply of inadequate pleading, and it wasn't a summary judgment on the basis of inadequate evidence.
Correct, Your Honour. Yeah, sorry,
Right.
Correct, Lord. Yes, it was indeed that is exactly the case.
But there are 2 points that arise in relation to the pleadings, aren't there? It appears to me. The first is whether you've pleaded sufficiently by reference to the emails, and the second is if that is sufficient on its face to constitute a potential variation, what then is to be made of clause 13? And that raises 2 distinct points, because if one of the emails is from one party and the other email is from another party, you've got an argument that you have a variation signed in writing by each party. If you don't get home on that, a further question then arises as to whether or not there has been a specific variation of clause 13 itself. And you probably know as a matter of English law, but not necessarily as a matter of UAE law, about which I'm not sufficiently expert, but fortunately we have a judge with us who is Shamlan al-Shuawi, knows all about these things. He tells me the law is pretty much the same, that one would be looking for a variation orally or in some other way that specifically varied clause 13 as well as the contract as a whole. And that hasn't been pleaded as I read the pleading.
And that's correct, my lord. It's not been specifically pleaded that clause 13 was varied. The pleading rather is that the right to have a formal pleading was waived by agreeing to the variation. Of course, that is most definitely the appellant's secondary alternative argument. The primary argument is that there was a written and signed pleading, written and signed variation. But indeed, yes, I acknowledge the point there, and I'm grateful for His Excellency Shamlan's direction on that. But certainly, the appellant's case is that legally, under UAE law, the legal entitlement that arises in terms of the ability to vary without the formalities is predicated under Article 468 and the waiver of that right. That is the legal position pleaded. Of course, the court is to take its own view on that. I'll come to that point in my submissions later, but in short, the appellant's point is that that point wasn't even probed during the initial hearing, and indeed it's submitted that there is a real prospect, not necessarily balanced probabilities, but a real prospect that argument would have been successful.
Well, what you have to show us is that there is a sufficient plea that stands up as a matter of law. That's what it amounts to. And the reason I raise the point is that it does seem to me there are two distinct points. I can understand what you say about paragraph 22 and paragraph 57, I think it is, in terms of pleading a variation of the agreement in relation to the delivery of gas oil and alternative products. But if the emails upon which you rely cannot amount to something signed in writing by each party, then you'd have to have pleaded, at least arguably have to have pleaded, the specific variation of clause 13. And that, I think, is, do you accept that that is missing, so to speak? That if you get that far, you're in trouble, so to speak.
If that is the situation under UAE law, and indeed that is what is exactly required, then I think that there may be more difficulty in relation to that. Right. And I'm willing to concede that. To clarify, I think the relevant paragraph which deals with this point is paragraph 22. I'll get the page reference, 1 second, sorry. Yeah. It's paragraph 20B, it's page B14. Paragraph 22B, Roman numeral 2. And it says, and the pleading here is, in the alternative, if it is found that this variation was not in writing and or not signed, it's averred that by expressly agreeing to be provided with this delivery without qualification and or by conduct in accepting the delivery without qualification, the claimant writer had to rely upon the formalities within the settlement agreement. So there isn't a reference within the pleading there to clause 13, but there is a reference to the formalities stipulated within the settlement agreement, which would necessarily constitute clause 13. So actually, sorry, I'll row back a little bit on my admission earlier, which is that it doesn't state that clause 13 was specifically varied, but I think the effect of that is that the claimant's the allegation is, or the pleading is that that Rada Trading had waived its right to rely upon clause 13. So the argument is set in terms of waiver as opposed to specific variation of clause 13.
Understood. All right. Well, that's very helpful so far as it goes. Chief Justice, do you want to ask?
Yeah. I know you lawyers look into technicalities to win your case with your clients, but your clients always think in terms of dollars and cents more than anything else. What is it that you started off by saying that this decision will sort of help parties to arrive at some solution, hopefully. What is it that you're looking from us? What is it that the parties are looking from us to decide that would help you? Maybe we can help you in, because as Sir Jeremy said just now, there's a claim of 8 million against you, against Cohenrich, which is going to go on. And your counterclaim is for what, 800,000 or something like that. You mean I've not seen any admission, well, denial of, like, of course, the question of whether the oil was properly delivered at the proper, port, in other matter. I mean, if, as a businessman, if you deliver oil at the wrong port, I'm not going to accept it. And you cannot force me to accept it. because oil is not the small item that I can move from Fujairah to Sharjah. I need a storage space to store. And if the agreement is for me to deliver at a certain place, then you deliver at a certain place. You cannot change your mind overnight and say, I'll deliver to somewhere else. So, I mean, where's your case there? I mean, I'm trying to find a solution, trying to be a mediator more, trying to get parties to, I wish the parties are listening to what I'm saying now. You know, so at the end of the day, what is it that the parties want? Cohenrich, you owe that unless you deny you're owing the claimant 8 million because you have been assigned, you are now the assignee, you took over the debt of the first defendant. Are you denying that it's been assigned to you?
No, well, sorry, for representing Cohenrich, I don't think that specifically is denied or said to be.
So it's a question of sit down and settle it. Why are you going to quarrel on technicalities? I have a lot of money for the lawyers get richer. At the end of their parties lose in every way, you know. And then if you know, it's just Shamlan was talking about saving costs. If you can cut down the issues, maybe we can save a lot of cost for parties.
Dear Lord, I appreciate what you say, in particular to the ports and where the delivery of the product shall take place. As the counsel of the appellant mentioned earlier, there have been negotiations. This was also the reason the previous hearing has been postponed. But so far, these are exactly still the sticking points. This is the point of delivery, the ports, and the quantities. This is still what we are negotiating on with the claim, with the appellant, and it turns out to be very difficult because also from the perspective of the respondent of Rada, this claim is undisputed. I mean, we're talking now really, as you say, about technicalities and procedural strategies, but not the subject by itself.
Yeah. I mean, if you wanted to decide, we'll sit down and hear the case and we deliver our judgment. But I think that's not the wise of business people to think like that. Business people thinking of how to save money, how to make things run more efficiently, instead of quarreling on technicalities. And that's what you're doing now, purely on technicalities. Sir Jeremy was speaking on technicalities, properly pleading, the law is like that, the law. But at the end of the day, what do parties get?
No, I'm grateful, my lord, and indeed the comments will be fed back, of course. From the point of view of Cohenrich, just as a very brief point, and I don't want to get into discussion with this with Dr. Azari because I understand that the parties are at odds over this. There is some dispute as to the which port things will be delivered to, and of course that I think that's acknowledged by Dr. Azari. From the Cohenrich point of view, of course, a sensible negotiated settlement is the best outcome, and indeed, whilst I appreciate that this exact forum is to deal with the counterclaim appeal, but I do note my lord's assisting comments in relation to that. As stated, it is hoped that after this hearing, there will be further impetus one way or another to resolve this case.
Why did you go for trial and fight it out? Prove all the evidence, whatever you want to fight it out instead of going on, because this is not going to solve the problem. We make a decision one way or the other. What happens after that? Assuming we decide against you, what's going to happen? Assuming we decide against the respondent, what's going to happen?
Well, the negotiations have been continuing all the way up until the hearing, even after it was confirmed that it was reached last week. Negotiations have still been continuing.
You should get a mediator to mediate.
I understand. I'm not sure I have all my all of the clients necessary within indirect communications for me to be able to reach an agreement today, my lord, I'm afraid.
Anyway, you want to go on to the hearing? I mean, it's up to you. You are here to, we're here to hear your case, you know. But that's my view. I don't know what Justice Shamlan has to say.
Well, I totally agree with you, Chief Justice. But here we are. I think we need to hear from the appellant, and then we'll decide on that. Please go ahead.
Okay, then.
Your Excellency, your Lords, can you excuse me for 1 minute, please?
Yes.
Thank you. Thank you.
Mr. Parroll, if you want to be technically correct, we're all your honours here rather than my lords.
It's, I'm very grateful, Your Honour. I did consult with a friend of mine who had a recent experience of the IFC Court of Appeal, and I suppose it's always better to go up, and yeah, always better to sort of do it that way. But of course, I understand with His Excellency Shamlan that it's His Excellency, but I am grateful. I know that in the Court of First Instance it's Your Honour as opposed to my Lord, but I wasn't. I'm grateful for the steer.
Nobody's upset or offended, but it helps for you to know, probably.
Absolutely, Your Honour. Thank you very much.
Well, we are used to expressing certain expressions, and you get into the habit of doing it. Excuse me. I need to charge. Yes, Doctor, you're back.
Yes, yes.
Okay, are we ready to proceed?
Yes. From our earlier discussions, am I right in thinking that the court is familiar with the background of this case, or would indeed the court benefit from a brief run?
No, I think you do. You don't need to go into the detail. I think you jump into the issue straight away.
I understand.
If we need clarification, we'll ask. We'll stop you. Okay, please go on.
Thank you very much, Your Honour. So we're concerned today with the strikeout application of Rada in respect of the counterclaim, because Rada have not appealed the judge's decision to strike out the claims against Wealthbridge and Cohenrich. So we're only concerned with that determination. Rada's strikeout application, for the benefit of the transcript, is set out at G1 to G2. The basis of this application is that Rada alleged there were no reasonable grounds as Cohenrich had failed to set out all the elements of a relevant course of action and had not satisfied the requirement to plead all the facts necessary to reach a pleaded conclusion. The judge, by the judge I mean His Excellency Al-Mahari, who I'll refer to as a judge in my submissions, gave judgment in respect of the application to strike out the counterclaim. This is set out at page J8 of the bundle. In particular, this is at paragraphs 25 to 26. I think these are the only paragraphs that exclusively deal with the counterclaim. And in short, you can see at paragraph 25 the judge, as halfway through a paragraph, having considered the counterclaim in some detail, I do not accept that it sets out a proper basis for variation. So the reason for strikeout was the alleged failure to plead a variation. And now there's two clauses that the judge references, clause 4, in relation to the forming an entire agreement and there being no ancillary agreement that could have been formed. But more importantly, and I think this is the main clause at issue, it's clause 13, which states that any variation should be in writing and signed by or on behalf of the parties. Now the second paragraph, paragraph 26 is the primary judgment in relation to this strikeout, in which it was found the counterclaim does not seek to plead that any written variation occurred, and certainly not that such a variation was signed. And now I stress there the word any, because this was not a finding that as to the quality of the variation, nor a finding in relation to the what evidence, whether there was sufficient evidence in relation to the variation as previously discussed. It was simply that there was no variation pleaded at all. So the first ground, there's 4 different grounds of appeal which are brought by the appellant in relation to these 2 paragraphs of the judgment. The first, and this is the primary ground relied upon by the appellant, it's a very straightforward ground, and it is in short that the judge has made an error in that he appears to have missed the part of the pleading which sets out the variation. Now, this was erroneous, as if we go to the bundle, and this is at B3, this is the defence and counterclaim, and at B30. So yeah, B38, paragraph 59, this is the start of the counterclaim, and it provides paragraphs 1 to 58 above are repeated here. And if we go to B14, which is at paragraph 22B, this is the first paragraph dealing with the variation. It states here, however, as detailed in paragraph 57B to C, in or around August 2020, the second defendant agreed with the claimant that it could repay the balance of the additional sum by providing monthly deliveries of other oil-related products. And then B1, this was a variation confirmed in writing by email and signed by the parties by way of email signatures. And just briefly, to deal with the entirety of the pleading, B35, on page B35, there is set out paragraph 57B. It states here, as evidenced by emails exchanged by Mr. Aurelian Pank and Arar Group advocates and legal consultants on the 12th of August and the 18th of August, in or around August 2020, as a result of the COVID pandemic, the claimant and second defendant agreed to vary the settlement agreement. And then the terms of that variation are then set out within that paragraph. As such, it's submitted that there very clearly was a variation, a written and signed variation pleaded within the counterclaim. The relevant authority in relation to this ground, and this is cited within the appellant's skeleton at paragraph 27, is Boas and Aventure, which provides that an appeal court should only interfere with the trial judge's finding of fact where it properly determines that the critical finding of fact is unsupported by the evidence, or where the decision is one which no reason could have reached. For the benefit of the transcript, the actual extract of that case is at page K100. It is submitted by Cohenrich that both of these criteria in this regard are met. This finding of fact by the judge, namely that there was no variation pleaded, is unsupported by the evidence, as the evidence within the counterclaim clearly illustrates that there was a written variation pleaded, and indeed it's submitted that no reasonable judge could have reached this determination had they reviewed the entirety of the pleading. That is the appellant's case in short, very simple. Now, Rada raises, from what I can discern, are three different submissions in response to this ground. Firstly, at paragraphs 7 to 13 of Rada's updated skeleton, Rada alleges that the counterclaim fails to plead any answerable case. And for the benefit of the transcript, I'm not sure if the court have individual skeleton arguments separate or are relying on the bundle for this, but there is a reference within the bundle, page P16. In this regard, Rada relies upon the DIFC case, First Rand Properties Holding and Damak Apartment Towers. Now, whilst it's not exactly clear what authority from this case is alleged to be relevant to this appeal, it appears as though Rada relies upon this judgment for two reasons. Firstly, it is understood that Rada suggests that First Rand provides that the pleadings are to be struck out when they fail to allege facts whereby a representation could be false. I think that case concerned, or that part of the case concerned, a misrepresentation. I'll go to that case, which is included in the most recent bundle. So that's at page P30.
I don't think that case is going to help us much, Mr. Burrell. So unless Dr. Azari wants to refer us to it,
I'm very grateful for
need
the
not go
indication.
there.
Indeed, I'm grateful for the indication, Your Honour. In that case, I'll move past my submissions dealing with First Rand. The only additional submission that I can understand that Rada makes in relation to, the additional submission of its first of the three submissions is that at paragraph 11 of the skeleton, whereby Rada alleges that no evidence was supplied as required in the terms of Rule 17.37. And it's assumed that in this regard that Rada relies on 1737.3, which provides that a party may serve with its statement of case a copy of a document necessary to its claim or defence. To clarify, this rule provides that a party may provide a copy of any document necessary, as the case may be. It's not mandatory requirement, states may. And secondly, as I'm sure the court will be very well aware, in pleadings before the DIFC court, exhibiting evidence is in fact not common. Often no evidence is exhibited at all, or if any, it's often just the most essential evidence, such as the contract. And this is not the evidentiary stage of the proceedings, this is the pleadings. As such, it is not necessary for Cohenrich to have exhibited the evidence of the emails. The second submission of Rada regarding this first appeal ground is set out at paragraphs 14 to 22 of its skeleton, and for the benefit of the transcript, that's page 16 to 17, sorry, P16 to 17. In short, Rada's submission is that an exchange of emails is in no way a valid basis for the variation of a written settlement agreement. And it further alleges that the counterclaim does not indicate where or how the settlement agreement has been varied. And finally, that Rada states that the counterclaim does not plead offer and acceptance. So firstly, in response to this submission, Rada's arguments are misguided as to the basis of the judge's finding. The judge made a finding that the counterclaim did not seek to plead that any variation occurred. As I've already discussed, this was erroneous. But responding to Rada's allegations, the judgment did not contain any findings that an exchange of emails is not a valid basis for variation, nor in anything in relation to offer and acceptance. And importantly, Rada did not seek to cross-appeal either. So without prejudice to this, So that the first submission is that the finding by the judge, and indeed the scope of this appeal, is in fact much narrower than Rada suggests. Simply that whether any variation was pleaded or not, and it's not to do with the quality of the variation or otherwise. In any event, Rada's submissions are erroneous. Cohenrich did plead exactly where and how the agreement had been varied, namely by emails exchanged, and indeed those emails identified the individuals who sent the emails and the specific dates those emails were sent. It's not necessary to plead offer and acceptance. You simply plead that an agreement was reached. That is common pleading practice. Further, whether emails are a valid way of varying an agreement, as stated, is an entirely different issue to whether a variation was pleaded at all. It goes to the quality of the variation, whether that met relevant legal provisions. That was not considered by the judge. Indeed, there was no evidence of the emails. As such, it could not have been considered by the judge. In any event, Rada has failed to provide any legal authority that confirms agreements, even handwritten agreements, cannot be varied by email. The third submission that Rada raises in respect of this first round, and the third and final, is that Rada alleges that there can be no variation due to there being no pleaded written signature of the variation. And Rada alleges that as the agreement was signed physically in person, any variation must be signed in person as well. That's what I understand their argument to be. Alternatively, Rada relies upon Federal Law Number 1 of 2006 in respect of e-transactions, which allegedly contains provisions relevant to e-signatures. So firstly, and again, most importantly, responding to this, this submission goes to the quality of the signature and whether this met any requisite law. This, again, is a separate issue as to whether any variation was agreed. As such, again, Rada misunderstands the limited nature of the judgment and this appeal, which is solely to determine whether any written variation was pleaded, which as previously submitted, it was. It's not an opportunity for Rada to make various additional submissions as to the quality of the alleged variation or signature, whether it met any law. The Rada did not cross-appeal these points. As such, they're outside of the scope of this appeal. Without prejudice to that submission, in any event, it's submitted that Rada's arguments can only be considered after the relevant evidence, namely the emails to contain the signature, have been produced, as these are necessary to review before determining whether the signature was sufficient to vary or not. As stated, the pleadings had not been finalised by the time of this, the strikeout application, and indeed this judgment, and it is certainly before the evidentiary section of the pleadings. As such, it would be impossible for the court to reach a determination on whether the pleaded signature was adequate. Without prejudice to those submissions, and again, as a further alternative response, it's submitted that there's no restriction in the contract which would require that any variation be agreed with physical signatures. Clause 13 doesn't confirm anything along those lines. And as such, it's entirely valid to vary by email and by electronic signature. Rada has failed to provide any law which confirms that a handwritten signature agreement can only be varied by a handwritten signature. And finally, in response to the allegations regarding Law Number 1 of 2006, whilst it may be possible that this law applies as a variation was agreed electronically, and I'll go to the law in relation to this, which is at page P43. And at page P43, we can see there the definition of electronic transaction, which is any deal, contract, or agreement concluded or performed in whole or part through electronic communication, which may constitute this variation, but no omission is made in relation to that. Even if it does apply, however, and so in this regard, I think it's important to just review Rada's justifications in relation to this law, which are set out at page P2021. Rada alleges in particular at paragraph 30 that the appellant did not plead any of the preconditions of Article 17 of the e-transaction law in its pleadings before the court of first instance. So the argument by Rada is that if the e-transaction law applies, the pleading is deficient because it does not include the precondition, or does not plead that the preconditions in Article 17 have been met. Unfortunately, this is this preconditions in Article 17 would not apply to any e-signature in this case. That's because Article 17, and this is at page P52. Just wait a second. And so page P52, Article 17, and this deals with secure electronic signatures. And that's a defined term within this law. A signature shall be treated as a secure electronic signature if, and then it provides what would be a secure electronic signature. There is a difference, however, between a secure electronic signature and an electronic signature. The difference, as I understand it from this law, is that where there is a secure electronic signature, this is presumed to be reliable, as opposed to an electronic signature where it is not necessarily so immediately presumed. But that does not mean that an electronic signature is not a viable way of agreeing any contract or indeed any variation. And if we go to, in fact, the definition of an electronic signature, this is at page 42, P42. Definition of electronic signature is letters, numbers, symbols, voice, or processing system in electronic form applied to, incorporated, or logically associated with a data message with the intention of authenticating or approving the same. And a data message is electronic information sent or received by electronic means, whatever the method of retrieval at the place of receipt. Those are relatively wide definitions, and it's submitted that an email with an email signature at the bottom of it could very easily fall within that definition. And an email with an email signature is exactly what is pleaded within paragraph 22b(1) of the defence and counterclaim. As such, it's submitted that the pleading is sufficient for the purposes of this law in any event, to the extent that this is even relevant to this appeal. Unless I can assist any more, I'm going to move on to the second ground. Now, this ground concerns the error of law in relation to the variation which was discussed earlier. I'll be relatively brief in relation to this, as I understand that the court understands the appellant's submission in this regard. It is simply to say that the judge erred in law in finding that simply because there was no written variation, there was no legal basis for the settlement agreement to have been varied. The relevancy to this case is because Cohenrich has pleaded in the alternative of paragraph 22b(2) that Rada waived its rights to rely upon any formalities, namely clause 13, by entering into the varied settlement agreement and or by accepting deliveries. Again, what I'll stress here is the relevant test we're concerned with is whether there is a strikeout as there were no reasonable grounds. So it's determining whether there was reasonable grounds is similar to the test in immediate judgment, namely whether there is a real prospect of successfully pursuing the claim. It's submitted that there is a real prospect of Cohenrich successfully arguing that pursuant to Article 468, Rada waived its rights to rely upon clause 13. So those are my submissions in relation to ground 2. Ground 3, again.
Sorry, before we move from ground 2, personally, I found very difficult to apply Article 468 to the point you want to make here. So can you elaborate that a little bit for me?
Yes, of course, Your Excellency. So Article 468 is of the Civil Code deals with where a debtor, where a debtor waives its rights, the right is extinguished. And in essence, it's my understanding that this provision of the Civil Code provides that, sets out the basis for a waiver of right. The allegation in this case is that if it is found that Rada entered into the varied settlement agreement, but that the formalities weren't strictly complied with, it's argued by Cohenrich that by entering into that agreement and/or by the conduct and accepting the delivery thereafter, they have waived their right to rely upon clause 13 of the settlement agreement.
Yeah, so you are saying the UAE law recognizes the waiver of debts, right? This is what you want to point here.
It's a waiver of rights as opposed to debts. I know that the article is couched in terms of debtors and creditors, but it does deal with rights specifically.
Okay, thank you. Yes, please.
Okay, thank you very much, Your Excellency. Moving on to ground 3, this is again an error of law ground and relates to the reference within the judgment to the entire agreement clause. Now, this is a secondary appeal ground, as it's not entirely clear to what extent the judge relied upon this finding, or relied upon this clause in striking out, but it's pleaded in the interests of fullness. So in the judgment, and this is at page J8, it provides at paragraph 25, having considered the counterclaim in some detail, I do not accept that it sets out a proper basis for variation. Under clause 4 of the settlement agreement, terms therein form the entire agreement. Clause 4 is an entire agreement clause. This means that at the time the agreement was entered into, there were no ancillary agreements and there was no representations relied upon outside of the settlement agreement. But it's not relevant to future variations occurring after the settlement agreement was entered into. As such, to the extent that this clause was relied upon to suggest that it's not possible to vary in the future, then that would be erroneous. But it's not clear that that's what the effect of the judgment was. And indeed, as stated, that it is pleaded in the interest of fullness. And finally, again, also very briefly, ground 4 is the nature of the application to strike out itself. Within the application to strike out, there's no reference or no suggestion that there was no written variation at all. And indeed, that was not, it was understood that was not the submissions made by Rada Trading at the time. As such, it submitted that by relying upon this, it was procedurally unfair of the judge to strike out on this basis, when that was not the basis of the application. Unless I can assist any further.
That's all. Okay, we'll hear Dr. Azhari now.
I found these results.
Yes. Dr. Azhari.
Oh, excuse me.
Yeah, okay. Can you repeat?
Yeah, dear Excellencies, dear Lords. Yeah, in this case, or the question of this appeal is, let's say, basically whether the appellant's pleading constitute a variation of the settlement agreement dated 30th March 2020. We had in the beginning already some discussions. The settlement agreement provides in Article 13, and I think this is the a key provision of the settlement agreement, that any variation of this agreement shall be in writing and signed by or on behalf of each party. Then the appellant in the in his defense and counterclaim, as he pleaded earlier, mentioned on page 31, which is in the e-bundle, B3. If you go to section 95, the appellant simply refers to paragraph 1 to 58. However, paragraph 1 to 58 is basically covering his entire pleadings, which covers several aspects. We had two defendants, we had law of tort. So in our opinion, this reference, this broad reference to the entire 30 pages pleading does not constitute a proper pleading, because the previous pages, 30 pages, have to a major extent nothing to do with the counterclaim. The appellant, for example, did not refer specifically to page or to paragraph 22, then his pleadings would be more understandable. And in the reply to the defense and counterclaim on page 20, the respondent denied that a settlement agreement has been varied. This is in the this is C2 on page 20. So it is not true that the appellant was not aware that the respondent was challenging that the settlement agreement has not been varied. Further, it's a case of the respondent that the appellant failed to plead all facts necessary to...
Dr. Azhari, before you proceed further, your complaint is that the pleading by the counterclaimant is too broad, paragraph 1 to 58, without specifying what paragraphs of the 58. Do you have any authority that you're required to be more specific in such instances? Do you have any authority?
No, I do not have now any authority.
Okay, thank you. That's great.
Yeah. I was saying, and
C2, page 20, yeah. Go on.
The claimant or the appellant should have pleaded all facts necessary to reach to a pleaded legal conclusion. And this is definitely what the claimant or the appellant didn't do. He didn't comply with his pleadings with with Article 13 of the settlement agreement, which states that the agreement can only be changed in writing and signed by or on behalf of each party. Instead, he said the variation was confirmed in writing by email and signed by the parties by the way of email signature. This definitely doesn't constitute a variation under Article 13 of the settlement agreement, because a simple exchange of an email with only a simple email signature doesn't constitute a written agreement. And also, if we look at the Federal Law number 1 of 2016 on electronic and commercial transactions. I will call it e-transaction law. It deals inter alia with the legal classifications of electronic signatures and electronic communication. And even in Article 1, if you go to the definitions of the e-commerce law, it's in the e-bundle. P7, if you go to the paragraph 1, it has, for example, on page 3, electronic signature, the definition of an electronic signature. From this, that the e-commerce law provides a definition of an electronic signature, we can also conclude that an electronic signature is not a traditional signature as it was required in Article 13 of the settlement agreement. But however, in case the e-transaction law is applicable, an exchange of emails do not constitute an electronic signature. First of all, if you go to the definitions in Article 1, you see on page 3 a signatory. The definition: a signatory is a natural or legal person who holds an electronic signature creation device, and by whom or on whose behalf a signature is applied to a data message by use of the device. And if you go to the further definitions, what an electronic signature creation device is, basically it is a soft and hardware comparable with DocuSign and other software modules, but it is definitely not an exchange simply by emails. So it is the case of the respondent that the exchange of emails, might they have a name under them or not, doesn't constitute a written agreement or a written signature.
Looks like we are going into the substance of the evidential part of the case now. Anyway, if it will help your settlement of your dispute, yes, please proceed. Yeah, go on.
Yeah. Last not but least, the appellant addressed in his pleadings that it was sufficient just to plead that the settlement agreement had been amended. This is generally speaking correct, but in this particular case, it was a major point of the pleadings, and it was clear from the first instance pleadings also of the claimant that this is in dispute. Having said this, the claimant should have been, Rada should have been more precise when, and most important, with which content the new settlement or the varied settlement agreement has been executed. And we also criticized in our pleadings before the Court of Appeal that you cannot plead alternatives. The claimant, or Rada pleaded in his defense and counterclaim that two variations, how the new settlement, the varied settlement agreement looks like. And this is by logic not possible. I mean, you cannot, because this is a fact, you cannot have you cannot plead alternative facts. You can only plead alternative legal consequences of a fact. You cannot plead that the claimant was driving a white car and a black car. You can only plead the legal consequences. For example, the claimant provided funds and it might be a loan. Alternatively, it might be an investment agreement. But Rada is pleading alternative facts. And if you plead alternative facts in the context of the conclusion of a contract, it is very evident that there is no offer and acceptance pleaded by the appellant. So to summarize, it's the respondent's view that the appellant failed to plead a written and signed variation of the settlement agreement and a proper offer and acceptance of the alleged varied settlement agreement. And as such, the first instance court has ruled a right decision.
Yeah. Is that it?
That's it. Thank you.
Thank you very much. Reply, Mr. Barra.
Thank you, Your Honour. Briefly, and I don't know if the court needs to address me or needs me to address them in relation to this. In relation to the submission of the paragraph 168, it's very common pleading practice within a counterclaim to state all of the paragraphs of the defence are repeated here. That is in fact the most common pleading technique I've seen in pleadings, both in the UK courts and the DIFC. If the court were to find that that was not appropriate, it would have massive repercussions and involve very significant duplication of pleadings in future cases. It's just common pleading practice to repeat everything. I even went back to my textbooks before this hearing to clarify, that is submitted in essence that it's not deficient to repeat all of the paragraphs of the defence in a counterclaim, and the fact that it includes some facts that may not necessarily be relevant or specific to the counterclaim does not render that pleading deficient in any way. As stated by or as conceded by my learned friend, there's no authority that repeating everything in that manner is in fact deficient. Moving on, my learned friend stated that it's not a sufficient variation under Article 13 for an exchange of emails to constitute a variation. That is incorrect. There's no provision within Article 13 providing the form of the variation other than it be written. If it is written, if an email is sent, that is a written variation. There's no requirement that it be transcribed physically in handwriting. In relation to the e-commerce law, my learned friend's submission was that an electronic signature is not a traditional signature as required by Article 13. Article 13 doesn't state that there has to be a traditional signature or a handwritten signature. It just provides that it has to be written and a signature. A sending of an email is sufficient for that purposes. And as stated earlier, an email signature would be
again, as I mentioned to Dr. Azhari just now, aren't we going into evidential now?
I understand. Yes, well,
that's the problem.
You're right.
If we go into that, then it might prejudice one party or the other. Should it go for hearing later on, So should we make any comment on it, or should we just decide strictly on the law of pleading, full stop?
No, you're very right, and indeed that was my primary submission within my earlier submissions, which is that we don't even have the evidence of this yet. these submissions really go towards the quality of the signature, which cannot be assessed without the evidence. As such, they're not within the scope of this appeal, which is whether any variation was pleaded, and it's submitted that it was. So I'm grateful for the steer on that. Finally, and very briefly, my learned friend says that you cannot.
Anyway, I mean, we wouldn't be able to decide on, I don't know, for myself, I'm speaking for myself. I don't know how we are going to decide on that without further argument on what amounts to, I know, Dr. Hazari, you mentioned about UAE law and things like that, but whether there are sufficient arguments for us to decide whether that amounts to writing, and you know, I'm sure there are a lot of authorities to support whether email is a form of writing, and email signature is for a signature which is recognized as proper signature. Those are things that I'm sure there are a lot of cases we support one way or the other.
We checked the case law. This agreement is governed by the UAE civil law, and we were not able to find appropriate case law, just explanations of the law. So basically, the Court of Appeal would have the honor or the chance to comment on this legal question, because in my opinion, it really depends. This question is crucial for answering whether Rada has pleaded a variation of the settlement agreement, because the pleadings of Rada, of the appellant, was there was an exchange by email, and that the email signature from a simple email constitutes a signature.
Azari, assuming we rule that there was no variation, what happens to the parties then? What happens?
Well, see, as we discussed at the beginning,
because there was an allegation that the claimant agreed to accept the delivery of the product at Fujairah. I think there's some agreement there, isn't it? There was a contention by the Cohenrich that claimant has agreed to accept the delivery as part payment, or that goes towards the payment of the debt, isn't it?
Well,
so if that's the case, why are you going to whether there's a variation now at this stage? Again,
well,
no, I should not be going into that, because I'm just throwing points for the parties rather than to the lawyers.
Yeah,
Lawyers
your Lord, it is true there was one delivery which was not in compliance with the settlement agreement. This is very true.
Accepted it.
Yeah, but it was an exceptional acceptance, and by this the settlement agreement itself was not varied. The appellant offered some products to the respondent, who was and still is, because of this case, under financial pressure. So the appellant offered products which are not in compliance with the agreement, and because he was able to sell it in the market without further difficulties, he once accepted a different delivery.
Was it accepted without prejudice or something? And there was a contention argument about prejudice.
I do not know. This I don't know. But it was an exceptional acceptance.
Okay. Have you finished, Mr. Barra? Is there anything else you want to say?
The only point briefly is just to reiterate the closing point I wanted to make, and it is relevant to what we were just discussing, which is that in fact I suggested that this court doesn't need to make a finding in relation to whether any signature is sufficient or not. the scope of this court is to find whether a written variation was pleaded or not. And indeed, on that narrow question, it's submitted. It very clearly was, and there's no need to go into the quality of the signature, which is outside of what the judge's finding was and outside of the scope of this case. But unless I can assist any further.
Judge Shamlan, any question to pose to the parties?
No, thank you. No problem.
Judge Jeremy?
No, thank you very much.
Okay, we'll adjourn for a while. We'll come back to you in a few minutes, Mr. Bara and Dr. Azhari. The judges went to the other link. Go back to the other link. Just hang on. We'll come back to you, Mr. Bara and.
So we stay here on this conference.
Stay here. You stay.
Yeah.
I mean, you can leave. You can. The registry will contact you in a few minutes. Maybe we'll take a break for about say half an hour or something like that.
Okay.
Thank you very much.
Thank you. Thank you. Yeah.
Thank you. So we leave these judges and then we go back to the pre. Okay. We have arrived at a decision, and our decision is that appeal is allowed with cost. Cost to be assigned by the assessed by the registrar unless parties agree to it, and our judgment will follow in a few days.
Okay.
I hope we can come to a solution. Honestly, Dr. Azhari, I'm speaking to you as a Muslim. Thank you very much.
We're trying hard. Thank you very much.
Okay. So thank you very much, Judge Shamlan and Jeremy.
Thank you.
This morning.
Thank you.
Do you want to have any? Do you want to have any further discussion between judges, Zaki?
Yeah, I mean later on now. Yeah, we can go back to the other link if you want to.
Okay, well, let's just do that for a couple of minutes.
Let's do that. Let's do that. Okay. Thank you very much.
Thank you.
Mr. Barres and Dr. Azhari. Thank you.
Sorry. Does the court do we need to stay on the link or
No. It's over for you. It's over for you now.
Thank you very much.
Okay. Thank you. Bye bye.